First off, just for the record, just your first last name, how you spell it, and your title.
My name is Gretchen Swen, but spelled Sween, and I am Robert Roberson's attorney.
And just real quick, just some background information. How long have you been representing Robert Roberson?
Since April of 2016.
So it's been a while now, almost 10 years now.
We're getting close.
Getting close. So another date we're getting close to is also Robert Robertson's execution, about 4 to 5 weeks out now. I guess I want to ask real quick, where do things stand when it comes to the appeals process after that last hearing that we had maybe month and a half ago now?
Well, back in February, we had filed a new habeas appeal with a whole bunch of new medical evidence supporting the actual innocence claim and further explaining Nikki's condition with the opinions of highly qualified experts. And that has been pending before Texas's highest criminal court, which is the Court of Criminal Appeals, since that time. So it is still up there. They're still deliberating. And that was our objection to the whole concept of setting an execution date. After the execution date was set, we filed two things fairly quickly. We filed an emergency motion for a stay of the execution so the court could continue its business, and also a motion seeking oral argument. And both of those pleadings are still pending. So there hasn't yet been a stay. There hasn't been a response to the request for oral argument. And the state has filed oppositions to those. But meanwhile, we also learned some new facts that led to yet another round of claims. And in August, we filed another large habeas application based on really newly disclosed information that affected the fairness of the trial really from the very outset. It had to do with both who gave the authorization without Robert's knowledge or consent to take his daughter off life support, and then how that was used to be able to accuse him of murder. And the fact that then the judges involved in that also then appointed him counsel who never pursued his insistence that he'd done nothing to harm his daughter, who simply conceded the whole case, said it was a shaken baby case. And since these are such foundational issues, and the fact that we were just learning who had played some role in this, they're new claims that really are about basic constitutional rights that were violated there at the outset. So all that is still pending. But meanwhile, the clock is ticking.
And you mentioned, all these appeals that are going on right now. How plausible is it to get those appeals done? And you also mentioned in oral arguments. How plausible is it to get maybe another hearing before that October 16th execution date?
There's no time. I mean, at any moment, the Court of Criminal Appeals could stay the case and take as much time as it wants. It's the boss. And certainly, if ever a case called for oral argument, it would be this one, I argue, because it's so complicated. It's this intersection between law and medicine. There's been this change in scientific understanding, massive change since the trial. And many of the judges on this court haven't been with this case, certainly as long as I have. And it's a very complex case. There are a lot of issues, a lot of facts, and they don't normally grant oral argument in this posture, but this case seems to be something that would benefit from it because there's also been a lot of misinformation about what the medical evidence really is. And so to air that out in a courtroom, I think would be very beneficial to the entire jurisprudence of the state.
If that were to happen, how's it decided on what courthouse or what jurisdiction that hearing is held?
It would be before the Court of Criminal Appeals, and so it would be more, very different from, for instance, the hearing in front of a trial court. It would be, um, each side would probably be given assigned amount of time, and the point would be to for the judges to be able to ask questions. So you can come in as a lawyer, you always want to control things and you never really have control, but you would come in there with a plan of what your main points are to emphasize, but the real goal is to hear what's on the mind of the judges and be able to address any questions they have in struggling with the case. But I have no idea if that's going to happen. And meanwhile, we just the fight continues to try to, in particular, raise awareness about Robert's situation.
I'm sure as his lawyer, you're in constant communication with Robert Robertson. What have you been hearing from him since the last time we saw him actually in the courthouse for the latest hearing?
Well, I think now, I mean, we had a pretty happy day yesterday. There was a little burst of hope and light when John Grisham made this announcement that he is watching and plans to write a book about this case. And Robert may be poor, disabled, incarcerated, but this makes him feel that he's not invisible. And for someone like Robert, I mean, this is just, it's a huge gift. And, he's a man with a lot of humility. And I don't think he quite understands how significant it is, but for him, he knows that it means somebody cares and people are paying attention. And so that makes me feel uh, good because I need him to focus on there being hope.
And then I'm glad you mentioned the book because that was going to be my next question. John Grisham, top-selling author, as you mentioned, keeping an eye on this case, writing a book coming out in June of next year. What does it mean for you? I know you mentioned what it meant to him, but what does it mean to you that there's an extra set of eyes or an extra set of attention on Robert Robertson's case?
Well, certainly the book itself isn't going to, come out and reveal this whole story in time to make a difference with where we are now. But I think it does, for me, sends a signal that this fight matters and that people are concerned and that Texas has an opportunity here to pull back from the brink of something, truly horrible. We talk a lot about the sanctity of life, and there's really no more way to offend that principle than to just blithely go forward with the execution of someone whom many people believe is innocent. And these are people that have studied the case because I will note that it's not like John Grisham just rushed in here out of nowhere. I mean, he is somebody who has written two very serious books about wrongful executions, The Innocence Man, and then most recently, Framed. And so this case got on his radar because of his own interest in that phenomenon. And he then studied the facts. He's written a long form piece of journalism about it. And then he came and he was invited by lawmakers to speak at hearings last year. So it's not like he's just parachuting in. This is somebody who's studied it and has made, a calculated decision that it is worth his time and energy to devote to, exposing the facts here.
I know it was either early this week or late last week, but there was a group of exonerees who came together in open letter. They were in an open letter. I don't know if you can tell me a little bit more about that.
Yes, it was quite moving. There are people in this country who have been wrongfully convicted, and some of the most, well, the most moving um, people to testify about that, what that really means to our society, the wounds to our society when that happens and when it takes so long to correct. I mean, so hearing from an exoneree is always a moving and educational experience, but this group came together of people who had been wrongfully convicted of hurting children, and several of them specifically had been accused using the shaken baby hypothesis that was used to convict Robert. And just describing the pain of being a parent or caregiver who's already in a crisis because their child is in medical distress and they are learning they're going to lose their child, and then to have it turn into an allegation against them and what that feels like. And for them to say they see themselves in Robert was just so powerful. Again, another message that he is not this nobody that has just been cast aside. There are people that see this.
I know around October of last year is when Robert Roberson was scheduled to be executed. That day was a lot of back and forths between the courts of whether to go move forward or not to move forward with his execution. Is that something we could see again come October 16th?
I mean, if prayers are answered, no. But that is the problem with this phenomenon. I mean, when you have it's very unusual. I mean, it's a unique situation in the criminal justice system when you identify a date when the state is going to put someone to death. And that's an absolute wall, that you have until then to change the end of the story. So up until the last moment, there will be a fight unless there's a stay from the court in the interim, and we're spared that trauma, because it's a trauma mostly experienced by the condemned for sure, but everyone around them is affected by this, um, including prison guards, including the witnesses on both sides. It is a traumatic experience, and I would say I don't want to make this about me, but that was truly one of the most horrific days of my life. And would not, I'm not happy to be back in this position for multiple reasons, but uh, the real issue here is, can we prevent the atrocity of executing an innocent man and simply give him a new trial when the medical evidence is what this case is about? And that still exists. It's locked in time. Nikki's medical history, the CT scans, the medical toxicology, the blood work, all the things that are relevant to understanding her situation are the same, but they've never been considered. What has changed is the whole notion of whether shaken baby syndrome is valid science. And so there's every opportunity here to have a new trial using all the evidence that is meaningful and get at the truth. And that's all we've ever been asking for.